one quick second about me and my team here. So as Russell said, I'm a healthcare lawyer, but really I'm a digital health lawyer. Been at it for really, I came back into private practice out of what I call the go-go years when I went and worked in-house at a tech company. So I came back in about 2001, 2002, and I've been working on these issues. Of course, back in, talk about the dark ages, 2001, 2002, there was not a lot going on compared to what's going on today. But I really play at that intersection of healthcare, the law, and digital issues. I lead a team here in Seattle. We work on a number of different kind of components within this ecosystem. What we're going to be talking mostly today is about that middle component, digital health strategy. All right. So the 21st Century Cures Act. This is, I call it a bit of a sleeper. This is a statute that was actually passed right at the end of the Obama administration. Okay. So December of 2016, it was really part of the, you think about the cancer moonshot. Joe Biden came out, one of the last things he wanted to do is push for some legislation that would fund cancer research and so on. Well, whenever a legislative train gets moving, it's very common to have a lot of cars kind of tacked onto that train. And one of those cars relates to what we're going to talk about today, and that is how data moves in healthcare. All right. So let's talk about what we're going to try and do today. I called it a game changer for digital health. By the time that we're done today, I want you to know what is this thing called the Cures Act, why you should care about it, and what the heck you should do about it. What are those actionable steps that you can take today that are going to impact your business today and tomorrow? Okay. All right.
Awesome.
So a little bit about, what is the Cures Act? It's hard to frame it up unless you look back a little bit. So it's hard to believe, but it's been 10 years since Obama signed not the Affordable Care Act, but the High-Tech Act, right? Which was part of the original stimulus package in February of 2009. The world is ending, right? Economic crisis. We have a new president, Democratic Congress, and he was able to actually get some legislation through. And one key piece of legislation was the High-Tech Act. The other people think of it as this is where the meaningful use dollars came from, right? $34 billion. It was essentially an infrastructure project. Okay, so there've been many attempts to kind of build out the IT infrastructure in healthcare. Remember, in 2009, I was working with certainly many physician groups, lots of hospitals that did not have electronic health records. Okay, kind of the dark ages, and it took an economic crisis and a new president to come in and to actually put some dollars on the table to really build out that infrastructure in healthcare. Okay, and what do we know about any big funding project, about any big government program? They're going to be winners and losers, right? So as I move on, and so who are the winners under the High-Tech Act? Who are the winners under meaningful use? For the most part, the biggest winner is that one in the upper left. Back here, if someone could mute, thanks. These are a lot of the big EHR vendors, and for the most part, these were the winners under High-Tech. Okay. One thing that's interesting about Epic that I think is worth noting. Epic's been at it a long time. They have been, and this is a bit of foreshadowing here in my talk, they have been masters at understanding public policy. Now, you could argue on High-Tech, they were just, kind of really good time from a timing perspective. But we'll talk about some other programs that they were able to read, understand, change their business models, and maximize, kind of combine their business model with what was going on from a public policy perspective to really grow their business. So over the last 10 years, 2009, big government program, these were really the winners. How about other folks? Like, what about patients? What about entrepreneurs? What about healthcare providers? Well, I think, fairly questionable results, right? If we know anything about some of these players, is that this isn't the most forward-thinking technology. I mean, this is just basic table stakes. We're going to take a patient record and make it electronic, right? But in terms of, for a lot of my provider clients, one of the things that has occurred is they're really locked into these vendors now. Right? It's very, very difficult to move. There's problems with interoperability, which has actually been frustrating for a lot of patients. And then for digital health entrepreneurs, the biggest frustration is that, kind of a combination actually of providers and these incumbent EHR vendors have been engaged in various, what I will call information blocking activities. And over the last 10 years, there's been a lot of feedback going to the government about this. And the narrative basically goes like this. It's like, look, the government funded this infrastructure project. Think of it as the government funding the federal highway system, okay? But those federal highways and the organizations that ended up with them, the organizations that built the highways and ended up with the money from the highways, they're now controlling what cars or what information can flow on that infrastructure, right? So those incumbent EHR vendors are engaging in behavior that is making it very difficult for entrepreneurs or patients or providers to get information in and out of that infrastructure, okay? And so not so much over the past 10 years, but really over the past 5 years, there have been a lot of complaints to the government. The question is, what were they going to do about it? And the 21st Century CURES Act became that vehicle, okay? So right at the end of the Obama administration, there's momentum for a law to get passed in December of 2016. And there were a lot of folks in the agencies that saw it as an opportunity to put into statute pro interoperability and anti-information blocking statute. And it got passed, signed by the president, and became the law of the land in December of 2016. The problem is that I think, there's been a fair amount of distraction since that time in DC, and not a lot of focus on this law. But the CURES Act is, the statute is passed, is the law of the land. The big question is, statutes are very general and high level. The question is, what would the regulations look like? How would the agencies define interoperability? How would they define information blocking? And that's what we found out 2 weeks ago Monday. Okay, so on February 11th, just 2 weeks ago, on the eve of the HIMSS conference, we got two rules that were dropped. One by CMS, the Center for Medicare and Medicaid Services, and the other by the Office of the National Commissioner of Health IT. In sum total, we're talking about 900 pages of rules. And this is the part where when I started reading these rules, I said to Russell, we have to change the focus of the talk, because if you're a digital health entrepreneur, as I said, if data is the currency in healthcare, these are the rules about how that currency can and must flow, okay? So.
But what was going on, David, prior to what happened 2 weeks ago? Like, the legislation passed, but it wasn't clear how data was supposed to be shared, and so the Epics of the world could interpret it the way that they chose to, which was not necessarily entrepreneur or, in many cases, patient friendly.
Well, I mean, so for those of us that are really focused on the issue, I mean, I've been making reference to the CURES Act for the last 3 years. In my discussions, like you gave the example of dealing with payers, right?
Yeah.
And that was an earlier example. But in doing that type of work, I've been invoking the statute for the last 3 years. What we didn't know is this. What we didn't know until February 11th of this year is, we have a Republican administration. Generally, Republican administrations are very anti-regulation, okay? So they could have said, yeah, the Obama administration, they passed this thing, but we really don't like it. We need to let the market decide what information blocking is. We need to let the market decide what interoperability is. We don't want to get in there and mess around. And they could have sent that signal. Instead, and I'll show you some quotes here in a second, they sent the opposite signal. they sent the signal that said, by God, we as the federal government paid $34 billion for this infrastructure, and we think that the incumbents are using it improperly. And we don't like regulation because we're incumbents. You know, the picture there of Seema Verma, who's the head of CMS, from the Modern Healthcare article, she stood up and said, look, I'm a Republican. I'm anti-regulation, but this has to stop. And we have to create an environment where innovation can flourish, where we can get value and a return on our investment in this infrastructure, which to me is a starter's pistol for digital health innovation, which for me is, because here's what's been going on. The Epics and Cerners of the world have been saying, look, we're going to do all that. Yeah, you may have some great idea for real-time analytics. We're going to solve that problem. And oh, by the way, you know, our customers have signed these agreements that put certain restrictions on them, so it's governed by contract. These rules basically say certain behavior is illegal under federal law. Okay, so again, to answer your question, I've been invoking it for the last 3 years, but now I have 900 pages that really kind of support a view of the world that is very innovator friendly, for lack of a better way to put it. Okay, but let me show you some text from the rules to kind of highlight that point. Okay, so this is language taken straight from, as you can see, page 206 of these of the rules, right? Where they say, look, here's what we're trying to do. We're trying to promote the efficient access, exchange, and use of EHI, which is electronic health information, to support a competitive marketplace, right? Incumbent vendors must not interfere with healthcare providers' use of their API technology in any way, especially in ways that would impact equitable access and use based on, for example, another software developer signed, current client base, or business line. I mean, they're basically saying, I mean, they're taking to task the incumbents who have been engaged in behavior that's very protective of their markets, but not encouraging innovation. Okay. The other thing that we're very interested to see is how would information blocking be defined? And in these rules, and they are admittedly proposed rules, and we'll talk about the whole process of rulemaking, but they defined information blocking very, very broadly. Okay. And then the other thing I think worth noting, just in terms of, I hate slides with lots of content, but some of these quotes were so important. I mean, here is Dr. Donald Rucker. He is the head. He is the head of the Office of the National Commissioner of Health IT. So he is the grand poobah of digital health in the United States government. Okay, and he is flat out saying that he is, you know, from his perspective, because there hasn't been this entrepreneurial activity in the space, because people haven't had access to the data, that they have put these rules out in order to foster new business models. Okay. Yeah. So if you are, so I think of different settings where this is important, and I'm going to talk about some case studies. Okay. But one thing that comes to mind that isn't totally tied into this case study, you know, if you're an existing company, and I mean, I know there's lots of investors and boards who come to me and they say, yeah, this is really great technology, but how are we going to get access to the data we need today? And how are we going to ensure that the incumbent vendors can't shut off the spigot tomorrow? And what I would say to them in the past is, well, you know, HIPAA says that the data can flow, that it may flow, and we'll try to appeal to this kind of broader policy argument that the data should flow. This statute and these rules back that up, basically saying that it would be against federal law for an incumbent EHR vendor to say, no, we're not going to allow the data to flow because we don't have to, right? Because the rules under HIPAA just say may and not shall. These rules insert a shall in terms of many, many, many use cases and examples. Okay, so let me just give you one case study. So this is a real live fact pattern a client that I started working with, before February 11th, before 2 weeks ago, and working with them going forward. But just how the impact of, your question, Russell, like what's so different about February 11th of this year? Let me run through this fact pattern and see if it highlights that.
Okay.
So this is a client that has a revenue cycle application, and what's their differentiator is they do a lot of real-time. They provide a lot of real-time utility. Okay, so it's doing like eligibility checks. It's actually processing payments. It's for a lot of cash only or private pay type arrangements. Okay, and they have a nice little niche, and they have a client base that was a lot of their client base in a certain specialty was using one particular EHR. And so they had worked over many, many years to make sure that they had the interfaces in place and or the APIs in place to get the data, okay? And then their biggest customer decided to switch to very big incumbent EHR vendor that's very protective, okay? And so they start discussions with that big vendor about how are they gonna get that data. And the big vendor says, well, you got two choices. You basically have one choice, and we created two. One is you need to go into our little app store offering, okay? So what does that mean right off the bat? Right off the bat, to go into that, you have to give up a massive amount. There's a huge revenue share component. So right there, it just undercuts their business model. I mean, flat out. They basically said to me, if we have to sign up for this app store, we're dead, okay? And so we were starting discussions with big vendor about a separate type arrangement, which would be, okay, it's like more of a consulting agreement where they would allow access to the data via the customer, okay, but on a one-by-one basis, so that they would have to go and get an agreement with individual customers. And every time they went to a new customer, everybody would have to go up to big incumbent EHR vendor and get permission. Mother may I, essentially. Okay? And in those agreements, there's all manner of kind of unfavorable terms about intellectual property and so on and so forth. Okay, I won't bore you with it, but these agreements were not friendly and essentially undercutting the ability of my client to continue with a service offering that big incumbent vendor, EHR vendor, doesn't have, okay? So I was rattling the saber of the CURES Act before February 11, 2019, with these rules, though, in place. Very clear, I mean, just spot on saying, and with all these different examples that are outlined in these 900 pages of rules. Now I not just have a saber, I mean, I have a tank sitting behind me. I have kind of the power of the federal government to where I can sit down with that vendor and say, you need to make this data available. And if you don't, I mean, it's inconsistent with federal law. And by the way, the penalties for data blocking can be as much as $1 million per incident. Now, there will be a gradient. Not every incident of blocking will be $1 million penalty, but the point is the government's saying we're really, really serious about this. Okay.
Dave, I would like to ask somebody on the phone or people on the phone to challenge a bit and say, yeah, yes, but what about ... So can anybody on the call kind of bring up an example or a scenario that might challenge what looks like this panacea of opportunity, but from a practical standpoint, there's still a lot of questions, risks, or uncertainty?
Yeah, I have a question. So, there are multiple factors that go into the data sharing, right? There's the technical ability to share the data. Then there are rights to the data, right, that may be withheld by the patient or by a provider organization. So how does the law differentiate between those considerations? Because I can get the architecture opened up and have a technical ability to access the data, but I assume I still need to get rights to use that data as well in some manner.
Sure. So for example, in this scenario, let's just take that question under the case study here, right? So and the way the rules don't look at, they don't necessarily get into like property rights on the data, but the underlying assumption is this, is that at the end of the day, the data needs to be in service of the patient, okay? And so there are various organizations that can touch that data in service of the patient. The reality is that with respect to this example, the provider organization that's trying to get claims paid, okay, they're saying, look, we want this functionality, all right? The EHR vendor is basically what's called a business associate under HIPAA. They're a service provider. They don't own that data, okay? And so the core, this is where HIPAA and the CURES Act really kind of intersect. And so given the kind of the covered entity to business associate relationship, you know, what HIPAA really says is that that data may flow. What the CURES Act says is if the provider organization says, I want it to flow, that the incumbent vendor cannot stand in the way, and that data shall flow.
Okay, so in terms of the layer of rights, so I'm a patient, I have rights to that data, I can block use of that data. I'm a provider organization, I have a patient's data in my system, so I also have the right to block use of that data. So it's essentially my data as the provider organization, or is it really the patient's data?
Well,
so let's say the example I would use is the patient signs a disclosure that says, hey, I'd like my data to be used for research purposes. The provider still has the right to block the use of that data by a third party for research purposes? Or is it the fact that once the patient says you can use it for research, the provider doesn't have a right to block it?
If here's the thing, I mean, the patient has, as between the patient and the provider, if the patient says, I want my data to go to this research study, that has to be honored by the provider.
Right. But in the event the patient has not been specific to a particular use case and the data is sitting in the provider systems, then the provider has control over whether that data is used in certain manners.
Right. So you think about it like and this is where, you know, again, there is this intersection with HIPAA and the CURES Act now. So, you know, a provider organization has the ability to use that data for treatment, payment, and healthcare purposes, okay? And those terms are, you know, broadly defined in HIPAA, right? And then there are certain, you know, limitations on that. So a patient can come in and say, look, I want my data to be, I'm very sensitive about my health data, so on and so forth. But so what's important to understand is like kind of the default set of rules about how health data can flow. So what is difficult about healthcare in general, let me just elevate one level. A lot of times people try to apply property concepts to health data, okay? And it kind of breaks down because the way that the rules interact, it's more about, it's not so much like a property right as it is under different use cases, who has permission to use and disclose, right? So for healthcare providers, there's a set of default rules. We can use and disclose the health data that we collect for a whole set of purposes, unless a patient comes and puts some limitations on that, right? Patients, they don't necessarily have like a property right to that data, but they can come and impose certain limitations on use and disclosure, okay? What happened over the last 10 years with this big infrastructure project is that these incumbent EHR vendors suddenly had a ton of control over health data that nobody contemplated when HIPAA was created, basically, right? Remember, HIPAA is from the dark ages, like 1996. So as, you know, HIPAA allowed a bunch of data to flow, and then we had the High-Tech Act, and we have this infrastructure. What evolved is mainly these large EHR vendors that were suddenly in position to assert quite a bit of control, in particular with upstart technology companies, where they could just say, no, we're not providing access and you can't make us, okay? And then you looked at provider organizations that we're trying to make them make the data flow. And the patients could come and assert some of those rights, but vis-a-vis the providers and the EHR vendors, there wasn't the right, HIPAA didn't have the right mechanisms, okay? And so that's the gap that the CURES Act.
And is there a way the CURES Act differentiates between primary data and, like calculated or inferred data from the existing data set? So for example, if I were Epic and I had a whole bunch of raw data on patients in my system, I probably will have built some analytical paradigms to turn that into kind of insights or scores or whatnot on those particular patients. So now I have primary data and I have kind of calculated values based upon that data. I assume this only applies to a primary data set, or does it start to actually force them to share other data they may have derived from the primary data?
So that's a really good question. The rules do not, it's an area where they're inviting comment. The rules do not go so far as to permit, like if Epic has developed this secondary data, it does not provide the ability for someone to come and capture. So like in my example, what they're looking for is just the core data. They're looking for core demographic data. They're looking for data about what procedures were provided and so on. But the other thing to note is that what it kind of lays bare is what rights does Epic have to generate that secondary data. It's actually it can be pretty limited depending upon the language in the underlying contract as to what secondary uses they can make. But if you're just talking about things like data, of course, Epic's going to have all manner of data about how their software runs, right? Or now that they're getting into the hosting business, they're going to have all manner of data about uptime of their systems and stuff like that. These rules would not allow you to get into and get access to Epic's analytic data about how their systems run.
Great. So maybe just to play back what I think I heard you say is, at the end of the day, the provider organization has control over how and in what manner that data is shared and used. And it's all about the licensing contract between the EMR vendor and the provider to define what the EMR vendor can actually do with that data.
Correct. So for example, there's a classic provision that you'll see in EMR vendor contracts talking about de-identification of data, okay? Some EHR vendors are getting very aggressive on this, and they say, look, we want to preserve the rights. We want you, customer, to grant us, EHR vendor, rights to de-identify the data and then do whatever we want with it, okay? That's not a default rule. That's something that HIPAA allows, but someone's going to have to negotiate and put it in an agreement. When I deal on behalf of a health system, I would never let an EHR vendor put that term in, and unless my client is fully aware of it and understands it and agrees to it. But the default rules would not give an EHR vendor the right to make a de-identified data set and do all manner of things with that data. A de-identified data set is very different than information about how hosting infrastructure runs, right? So here's the thing, like some people say to me, how come these rules are 900 pages long? And the answer is they go to great lengths to try to work through a number of different scenarios. I think the final rule and all of its commentary is going to be much longer because you're going to have people coming up with lots of questions and use cases that they haven't addressed yet.
May I ask two questions? One is, when do the rules go into effect?
Sure. So, and Russell and I were talking a lot about this yesterday. The statute is in effect today. It is the law of the land, okay? So it's not to say that this is like a proposed piece of legislation, right? The rules, though, so the regulations, so like all this nitty-gritty detail, it's in proposed form now. The comment period ends on May 3rd. So we're in this 60-day comment period. And then the rules will be final thereafter. There's no, I cannot tell you, I don't have a crystal ball as to exactly when. If I was trying to assess, I think, by the end of the year, certainly by the time HIMSS rolls around next year, which is next March, I would say I would fall out of my chair if we did not have a final rule by then. Typically, what will happen on a rulemaking sequence like this is they get the comments back. It's spring. They review things through the summer, and we see something, in the fall to winter. That would be like a normal cycle. But there's no absolute drop dead date on when they have to publish the final rule.
Dave,
from what you're describing, the information sharing must be done on a patient-by-patient basis. Does anything apply to startup vendor that wants to get the data for a whole class of patients, to get all clinical lab results from a particular provider systems?
No, to be clear, the rules do not require on a patient-by-patient basis. So, for example, in this case study that I'm working through, what we're working towards now is an arrangement where, my client is going to be just another business associate of their provider clients, and so the data can flow to them in aggregate form. In all patients whose claims need to be processed on this platform, that data all can flow to my vendor, to my client. What the CURES Act helps is it keeps the incumbent EHR vendor from saying, we're not going to play nice on setting up that API. Okay, but in no manner does this require, or does the CURES Act say that data can only flow when you have an individual patient request?
David, what about payer? Dwight had asked the question. What about payer data? Does the CURES Act address startups' access to payer data? Claims data.
It does. So what you'll need to know at the end, and we're going to talk about next steps and the importance of actually looking at these rules. The information about that applies to payers is under the CMS rule. The good news is it's actually a bit shorter, but the interoperability and anti-data blocking rules apply to payers as well.
Ooh. Okay.
So it's a little bit trickier. Like if you, so like a great example is, let's say you had some application or service where you are aggregating, like, as people sign into your service, individuals, they sign an authorization where they're actually requesting claims information from payers. Okay. CURES Act helps kind of bolster and stand behind when you go to the payer. So Russell, in our former life, we're working with every move. This would have been a very, very, very helpful tool. Yes.
Yeah, great.
Yeah, so this is Dwight. This is pretty interesting. So I used to work for a company called HMS, which is the largest aggregator of Medicaid data in the country. They have 6 or 7 petabytes. And they essentially coordinate benefits. So through the TPA law, they health plans were required to offer up licensed agents like HMS their data, all of it, EOBs, claims, both commercial and Medicaid, because the objective was to make sure that Medicaid was the last payer of choice. And so these guys basically are, the 800-pound gorilla and the chase and pay. So imagine, huge opportunity to affect, disease management, risk management, all that. But the health plans obviously weren't very happy about this, so they wrote extremely narrow DUAs. And so I could see if what you're saying, David, is that they now, by law, just like that TPA, have to broaden their DUAs I could see, companies like HMS and other companies that want to innovate off of that data set. That's a game changer in what we're trying to do in healthcare.
Yeah. And I mean, as you look through the rules, and this is the thing, I mean, I get it. This is kind of obscure stuff, but that's why I feel like, I said to Russell, I need to kind of stand on the mountaintop here and make sure that people that care about this stuff understand how far reaching these rules are. The government is basically saying the only way that we're going to move the needle on value-based care, on the quadruple aim, is if we do a better job of making sure that people that can take actionable steps with the data can get access to the data. Now, we still need to make sure that privacy and security is protected, et cetera, but we're not going to allow companies that happen to get into position of having a ton of data just by virtue of, in some cases,
their vendor role.
Yeah, we're not going to allow them to make arguments that, I mean, the classic is, oh, we can't release that data because, or providing access to that data would reveal our data structure and that's proprietary and so on. And the government's basically saying no. Now, there are provisions, of course, that we have to, maintain privacy data. So you can't have a private company cannot knock on the door of some big health plan and say, give us all your data, right? There has to be, we still have to follow HIPAA, right? But what people that work a lot with HIPAA know is that HIPAA says that data may flow to a lot of different settings, right?
Yeah, the problem is these companies are really good at being passive aggressive.
Exactly.
And that it's going to be another 20 years before we get to a place where the data is flowing. My question really was that I posed to Russell was actually a bit loftier and bigger. And if you follow Eric DePaul, he's a big advocate that patients should own their own data. And imagine a world where you've got you own your own longitudinal patient record, and it follows you everywhere, right? That's the only world where you now have a complete longitudinal record over your lifetime, and you can start doing some real disease management, right? Imagine being able to track all the data for one patient that has, a particular disease or comorbidity of diseases. But that opens up Pandora's box on who owns that data, how does the patient monetize that data, or do they? And then secondarily, bigger society issues around who owns, how much of the data in a mass way that society say, regardless, we are going to own this data because it's for the good of society. And, you're not going to have a choice citizen on, who uses it, who doesn't for these particular purposes over here.
Yeah. And these rules definitely, get into those questions. It's like, another way to frame it is the way the rules work today is, as between two parties, who has the right to direct the use and disclosure of that data?
Yeah.
So, as between a healthcare provider organization and a patient, it's always going to be the patient, with a few exceptions. As between a healthcare provider organization and a technology company, it's almost always going to be the provider organization. And as between a patient and a technology company, it's almost always going to be the patient, okay? With again, a few exceptions when you talk about things like de-identified data sets or metadata and so on. But here's the thing, folks. Here's the bottom line if you take nothing else away, okay? Over the last 10 years, we really accelerated digital health, but for the most part, we just digitized a bunch of paper records, right? That's essentially what we did. And data is still flowing for a lot of payment purposes. But in terms of things like precision medicine and decision support and a lot of the research initiatives and so on, this set of rules is going to have just a massive impact. It really does. It's going to set the tone, and those who understand and can master these rules, I mean, I don't see how you can have a business in this space and not, just like you had to understand HIPAA with phase one of all this, you're going to have to understand these rules. And business models are going to have to be tweaked and changed and updated. And some people might say, well, should we do anything now? The rules only proposed. We won't have a final rule for a while. Let me tell you, you have an opportunity to have a head start. And those that are paying attention, I mean, okay, frame it this way. John Doerr of Kleiner Perkins, all right? That John Doerr was at HIMSS last week. And the first thing that he talked about was these rules. So I'm saying to myself, look, I live in the space. This is what I do, right? Like, of course, I'm all over this. But sometimes I have to, like, say, I got to put it in perspective, right? Should other people really care as much as I do? And that, in part, answered the question for me. When John Doerr gets up on the stage and starts talking about winners and losers under the CURES Act rules, he clearly is thinking about and informing his portfolio companies to make sure they understand how these rules are going to impact their businesses.
Yeah. Dave, just time checking here. We have about 10 minutes.
Okay. May I ask another couple questions? One is if we are a vendor who.
Go ahead.
One is if we are a vendor. One is if we are a vendor who accumulates data from providers and patients. Do we then need to disclose it ourselves to other technology companies who request it from us? That is, this would be indirectly, not from the provider or the patient.
Yeah. So good question. So let me say it back to make sure I have it. So you're saying if you are a technology company and you have stores of data, you know, what are going to be your obligations to provide it to other companies? Let me answer it in two parts. Let me answer it in two parts. Part one is there is a majority of these new rules apply to what's called healthcare developers of certified health IT. Okay, what is that? Yeah. That is health information technology that was certified under the HITECH Act and therefore was a trigger to the meaningful use dollars. Okay, so the majority of these new requirements hit the incumbent EHR vendors. Okay, so that's the interoperability part of the rule. The data blocking part of the rule is broader, and for the most part, if you read through the rules and all the examples, the focus is healthcare provider organizations. Okay, so what the government, just like the government is concerned about the Epics and Cerners of the world being data silos, the government is also very concerned about hospital system A not making data available to hospital system B when the patient moves between. Okay, so there's tons of use cases on data blocking and so on and so forth. I think, though, that if you are, you're neither a developer of certified health IT nor a healthcare provider organization. You are some other health IT company. The data blocking rules will apply to you, but there'll be much fewer kind of use cases where they apply. But when I say that, you know, you'd be crazy not to, I mean, we've been talking a lot about small vendors that need access to data. You provide a little bit different example. And I think it's going to be very, very important for organizations that possess data today to understand at what points they might be accused of blocking data. So most of the time, the rules of the road for organizations like yours will be governed by your contractual arrangements, okay? Because you don't have that direct kind of patient-facing obligation, and you're not providing certified health IT. But there will be instances, I think, the rules are broad enough on data blocking that you could find yourself in the crosshairs. And so it's going to be really, really important to read through the rules and make sure that you don't run afoul of them.
Thank you. And the second question is about charging.
You ask this next question, then Dave, I want you to be able to wrap up your detail. And then, by the way, if anybody has any questions that we didn't get to, you put them in chat. I'm documenting them, and we will follow up. Dave will answer those after. So I just want to make sure nobody feels shafted. Go ahead.
Terrific. What are reasonable charges that healthcare IT vendors or secondary vendors may charge for access to the data?
Yeah, and this is a great question. One of the most interesting parts of the rule ties to this. The government, this is one of the areas, and I'm going to slip to my last slide here. This is one of the areas where the government is very, very specifically asking for input from industry, okay? But here's the concept in the proposed rules. What they're saying is essentially you can charge the kind of actual costs associated with work that you would have to do to get the data out, okay? So if I go to Epic or Cerner and I have a client and there's some custom API that has to be written, Epic, Cerner, they can charge, and the only person that can really write it, the only organization that can write it is them. They don't have to do it for free. But what they can't do is say, oh yeah, by the way, we'll provide you access, but you have to give us 20% revenue share on any business that you run on the other side of the data stream. That's what they can't do, okay? So what the government says is, and they have this kind of concept about like reasonable, necessary, but it gets to this idea of like the actual cost with the work to be done. And then they say, look, we invite comment from the industry, but their point is that there should not be any gouging. But that is one of the most important things to look at down the road, which is maybe a good segue to this last slide, my three next steps, right? Should I pivot to that, Russell? Does that make sense?
Yeah. Rock and roll.
So look, so I realize there's a lot here. If you guys are playing in this space, you have to take a look at these rules and perhaps comment on them. I will, on the last slide, if you guys get me your email, I will send to you kind of a resource page that has all the links to the rules and some summaries and some digests that the government has put out that can be kind of a good entry point. Number two, of course, you got to really think. There's no one size fits all here, folks. But you have to think about how these rules are going to impact your business. Because if you're in the digital health space, they will directly or indirectly impact your business going forward. All right. And then third, of course, is then adjust your business plans accordingly. Mm-hmm. I got that comment deadline up there. Here's my contact info. You shoot me an email. I'll get you the kind of resources to kind of start you off on looking at some of the source material. And I appreciate your time.
Awesome, Dave. A couple of things. Some of you were asking questions in the chat, which I appreciate and honor. I have documented all of those, and so I'm going to be sending those follow-ups to David. David, maybe you could answer those on email, and we could share them back out with the group so nobody feels shafted. The other thing is, guys, David Schoolcraft, he's only $100 an hour. No, I'm just kidding. But he is okay, that's like legal humor. Okay, but David is phenomenal in the sense that he understands the business of business and the business of healthcare. So I have found it a gift, Dave, to be able to work with you. I also indicated on the registration that there would be an individual on the call who I would invite to have an hour strategic finance call with me. And I wanted to extend that invitation to Adam Kassan, who he happens to be a fellow Techstars brethren too, at InScope. And Adam, be happy to follow up with you, and if I can help in any way. There was just another chat. I want to make sure I see it. Can you post both your emails here by chance? Yeah, here's the thing. I am going to be emailing out a follow-up with all our contact information. You're going to have access to the slides and to the video. within the next 48 hours. So you will have easy access to everybody that you need. My responsibility, yeah, awesome. My responsibility is to keep bringing these topics to the forefront. I only care about one thing. I care about one thing, which is what do I need to do to help arm you to move your business forward faster? Yes, I want to take over your back office. I really want you to stay in your genius zone. If there are topics that are interesting to you, please share them with me. I'm out there to try to bring resources to you and help you. And hopefully, you found this one today to be valuable. So Dave, thank you so much. Thank you so much for attending. I hope you found this to be a worthwhile hour.
It was great.
Great. Thanks very much. Appreciate your time.
Thanks, everybody. Have a great day. Thank you again.